Can the government compel you to speak in opposition to your own beliefs? That very question came before the United States Supreme Court yesterday. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. The second big case in the 2022 term of the Supreme Court came to oral argument yesterday. This is a case of compelled speech, and specifically creative service that violates the religious conscience of the Creator. From the questions the various justices asked, one can almost predict the outcome. And today, I'm going to take you step by step, almost paragraph by paragraph, through the transcript. Before I begin, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, including this t-shirt that I have chosen for today, which reads, "Wake up, woke down." And that is what this case is all about. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do so long as it's legal tender. Now then, you will recall that on July 2nd of this year, I gave you a list of the 3 biggest cases of the 2022 term of the Supreme Court. I'm going to recap those 3 cases in the order in which they have come or will come to argument. First up, Students for Fair Admissions versus President and Fellows of Harvard College, docket number 20-1199, and Students for Fair Admissions versus University of North Carolina, docket number 21-707. The court at first consolidated these cases and then deconsolidated them. The 2 cases do not present exactly the same questions. Also, Justice Ketanji Brown Jackson had to recuse herself from the Harvard case, but not the UNC case. But they share one question in common: whether race can be a factor in college admissions. Accordingly, the court heard argument on both cases on the same day. The tone of the questions and the numbers of justices who took different tones suggest an outcome favorable to SFA. Next, we have 303 Creative LLC versus Aubrey Elenis et al., docket number 21-476. This is the case that came to argument yesterday. The question at issue in the court's grant of review reads, and I quote, "Whether applying a public accommodation law to compel an artist to speak or stay silent contrary to the artist's sincerely held religious beliefs violates the free speech clause of the First Amendment." Close quote. And last, and just to tease you up on this, because this case comes to oral argument tomorrow, Moore versus Harper, docket number 21-1271. This redistricting case asks whether a legislature can tell its state Supreme Court to go pound sand when it comes to drawing legislative and congressional districts. The court will hear argument Wednesday, December 7th. Now, that second case, the compelled speech case, concerns us today. Reportage on the nearly 2.5-hour argument session comes from The Hill, Patriot News Feed, and Todd Starnes' blog. In addition, you can listen to an MP3 recording of the proceedings or read the transcript. I have left links in the description to the docket listing for the case and the recording and transcript of yesterday's argument session. The case is all too familiar to anyone with a religious conscience. Laurie Smith runs 303 Creative, which creates websites for, among other things, wedding announcements. The problem is, she lives and runs her business in Colorado. Colorado, one of the wokest states in the Union, has an anti-discrimination act. Under it, any creator must accept all comers and keep silent about her faith. This is a pre-enforcement case, so no pair of same-sex roommates sharing bed is involved. All the arguments for this law come from government attorneys. They are Eric Olson, Solicitor General for Colorado, and Brian Fletcher, Deputy Solicitor General of the U.S. as amicus curiae. And I know I've told you this before, but it bears repeating. The Latin phrase amicus curiae means literally friend of the court. Kristen Wagoner of Alliance Defending Freedom argued for Lori and her business. Justice Clarence Thomas must have known instantly one problem the petitioners might have. Is a pre-enforcement case ever ripe? If two same-sex roommates had come to 303 Creative, gotten turned down, and then reported the turn down, that would be ripe. No one would question that. But that hasn't happened yet. Ms. Wagoner reminded the court that it has heard pre-enforcement cases before. Furthermore, and this is key, Colorado has a history of very aggressive enforcement of such woke laws. That alone chills the speech of 303 Creative. Justices Kagan, Sotomayor, and Jackson argued through their questions in favor of compelled speech. In one sense, Justice Elena Kagan ought to have recused herself because she is of that alternative lifestyle. So I regard her questions as self-serving. She led by trying to split the hairs between a dry announcement and more elaborate, typically gushing sentiment. Wagoner was having none of that. An announcement is speech, and the Colorado law compels her client to announce that which, according to Scripture, cannot exist. Justices Sonia Sotomayor and Ketanji Brown Jackson also tried to split that hair, but Wagoner held firm. Sotomayor then addressed one question that illustrates a tremendous problem with current precedent. She asked whether someone could refuse to serve an interracial couple. Now, of course, nothing in Scripture forbids people of different, quote, races, whatever they are, to marry. The court itself has an interracial couple. Look at Clarence Thomas and his wife, Ginny. Well, naturally, Wagoner wasn't going to assert a right to refuse service to such a couple. So Sotomayor tried, as have many before her, to equate sexual orientation with race. Justice Neil Gorsuch brought the questioning back to the law and asked about laws in states other than Colorado. Wagoner cited friend of the court briefs from 20 states supporting her client. Justice Amy Coney Barrett elicited a statement that 303 Creative's objections to compelled speech do not limit themselves to same-sex roommates. 303 Creative would not necessarily build a wedding site for a man-woman couple if their ideas of what marriage is also contradicted Scripture. We now turn to the argument by the government lawyers, beginning with Eric Olson, Solicitor General of Colorado. Mr. Olson opened his argument by equating religious beliefs with racism, sexism, and other forms of bigotry. Immediately, Justice Thomas jumped on that. What, he asked, is the history of laws applying public accommodation doctrine to speech or creative expression? Olson tried to say that it makes no difference in current precedent. Well, Chief Justice John Roberts cited a case saying that foster care or adoption was not the same as, say, hotel accommodations or travel tickets. And then Roberts took apart another precedent on which Olson relied. This was Rumsfeld versus Fair, involving providing a room in a law school for a military recruiter. Now, presumably, the recruiter was looking to sign students up to be military judge advocates, the legal eagles of the military. The fair in this case is fairness and accuracy in reporting. not the Federation of Americans for Immigration Reform. Empty rooms don't speak, Roberts said, and to that Olson answered that compelled speech was still a legitimate power, period. Justice Samuel A. Alito forced Olson to admit that 303 Creative does not outright refuse to serve a pair of same-sex roommates in any context other than a wedding. Alito also tripped Olson up on the equation of religious beliefs on marriage with bigotry. I quote the relevant exchange. Question: in light of what Justice Kennedy wrote in Obergefell versus Hodges about honorable people who object to same-sex marriage, do you think it's fair to equate opposition to same-sex marriage with opposition to interracial marriage? Answer: yes. And that's the rub. Justice Gorsuch probably gave Mr. Olson the hardest time. First, he asked whether the stipulations Olson made vitiated his entire case against 303 Creative. Those stipulations addressed how far could compelled speech go. For instance, can the law compel a freelance speechwriter to write a speech for someone with whose ideology he disagreed? Incredibly, Mr. Olson said yes. How does that square with protecting freedom of religious expression? It doesn't. And Justice Gorsuch knew it. Todd Starnes tweeted out a minute-and-a-half video of the next exchange between Gorsuch and Olson. I've left a link in the description. But now, I'm going to read that exchange to you out loud. Settle in, ladies and gentlemen, and pay attention. Answer from Olson. The company here says in no uncertain terms will they ever sell a product or a service to a same-sex couple permitting that I... Question: no, what they say is we will not sell to anyone, a message that I disagree with as a matter of religious faith, just as a speechwriter says, or the press release writer, the freelance writer, says, I will not sell to anyone a speech that offends my religious beliefs. Answer: but here they are defining their service by excluding someone based on their... Question: that's their religious belief. Answer: well, in Colorado... Question: you can't change their religious belief, right? And you protect religious beliefs under the statute, right? That is one of the protected characteristics in theory. Answer: yes, and in practice. If it wasn't in practice, we'd have heard about it over the past several years. And my friend has pointed to no example where this has been applied in a... Question: Mr. Jack Phillips of Masterpiece Cake Shop did go through a re-education and training program pursuant to Colorado law, did he not, Mr. Olson? Answer: he went through a process that ensured he was familiar with... Question: it was a re-education program, right? Answer: it was not a re-education program. Question: what do you call it? Answer: it was a process to make sure he was familiar with Colorado law. Question: someone might be excused for calling it a re-education program. Indeed. At this point, Justices Brett Kavanaugh and Amy Coney Barrett got their licks in. Before I describe that, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me, many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, They can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. As I was saying, this was Eric Olson's day to fall into logical traps. Justice Brett Kavanaugh set the next ones. First, he tripped up Olson on precedents and interesting distinctions. Kavanaugh brought out that if a publishing house has First Amendment protection, why not a website designer? Justice Barrett asked whether a newspaper could decide during a certain month to run marriage announcements for same-sex roommate pairs only. Mr. Olson fell neatly into this trap by saying yes. Justice Jackson tried to rescue Olson on a narrow question of whether an expression belongs to the web designer or the designer's client, or at least that's how the transcript reads to me. And from my read of Olson's answer, he did not take the lifeline that Jackson was trying to throw at him, such as that lifeline was. And now, Mr. Fletcher. Oh boy. Fletcher began with the Rumsfeld case, saying that, and I quote, compulsion of speech is permissible because it is instrumental to a content-neutral regulation of conduct, unquote Brian Fletcher. Well, Roberts at once disagreed, challenging Fletcher to cite one case in which the court compelled speech contrary to one's beliefs. Fletcher tried to make Rumsfeld that case, but clearly Roberts was having none of that. Neither was Justice Barrett, who pointed out that all the law schools had to do was provide a room and maybe announce time and place for recruitment. And then Barrett asked whether Fletcher would apply Rumsfeld to require the school's career development office, or the CDO, to provide detailed statements to students about what a judge advocate is and career tracks in the Judge Advocate General's Corps, or JAG Corps. Law school CDOs always provide that kind of service to conventional law firms. But what is the JAG Corps except one of the biggest law firms in the country, if not the biggest? Fletcher seemed to entrap himself as neatly as Olson did. He did not suggest that the school's CDO would have to make such a recommendation, such an accommodation. Why then must 303 Creative? Kagan and Sotomayor tried to rescue him by asking whether 303 Creative's standard wedding website included a line about celebration of marriage. Fletcher could not remember whether it did or not. This led Roberts to point out that everyone who visits 303 Creative's company website knows where that business stands. Fletcher then wound up saying that the law could compel the company to do something contrary to how they represent themselves. Barrett and Kavanaugh trap him further. For Fletcher, the session went from awful to good grief. Justice Barrett asked whether a web design firm with alternative lifestyle ownership would have to design a site for a Christian club. Fletcher said no, because that's not discrimination based on status. But why? Asked Barrett. Can't we observe that both this hypothetical company and 303 Creative are discriminating, if you call it that, on message? Fletcher insisted on making a distinction without a difference. Justice Alito bore down on this, asking what public accommodation means and how far a state could take the concept. Justice Kavanaugh laid the neatest trap of all. He asked Fletcher to distinguish, if he could, a wedding announcement from a freelance speech. Here's the exchange. Question: you don't think applying a public accommodations law to a speech writing business that offers to do speeches or press or public relations releases for anyone, but they say, oh, we're not going to do this message. You don't think that they would say that's this case, and you say it's not. Because? Answer: I think they'd be wrong. Speechwriters aren't likely to be public accommodations. Set that aside. Question: until they are. After this case, if you prevail, I mean, that's what states could do. Bingo! Not even Justice Jackson could help Fletcher after that gaffe. By now, I'm sure you can all see the pattern here. We deal here with double standards and with selective application of the Constitution. That bird won't fly. Not with this court, it won't. Kristen Wagoner then had time to rebut the arguments of Messrs. Olson and Fletcher. She began, and I quote, "The United States says that you can refuse to express messages unless those messages are about marriage and unless those views on marriage have to do with believing that marriage is between a man and a woman. That's a significant concession that the government has made," unquote Kristen Wagoner. She addressed all the hair-splitting and distinctions without differences Olson and Fletcher made. Then she said Colorado's act defines public accommodations so broadly that one would lose First Amendment protections merely by opening a business. After denying that the court has ever allowed compelled speech, she concluded, and again, I quote, "In the end, it is not Ms. Smith who is asking you to change the law, but Colorado. This court should affirm, again, that public accommodations laws cannot be used to compel speech, and that this includes artistic expression, photography, painting, calligraphy, and films, forms of media that the lower courts have shockingly refused to recognize as speech when it comes to marriage. And yes, this court should give guidance to limit the cruelty that has been imposed by endless litigation on artists like Jack Phillips. One need not agree with a particular belief to affirm that law-abiding people have a right to speak their conscience, including on a controversial subject like marriage," unquote Kristen Wagoner, who, to support that, appealed to the Golden Rule and to the basic principle of self-government. Now, either Olson and Fletcher are not particularly bright, or else Mr. Justice Thomas has been holding seminars with his fellow conservatives on the fine art of logical and rhetorical entrapment. Or else, as seems more likely, Olson and Fletcher got stuck with the scut detail of defending the indefensible, and incredibly, neither man seems to understand why their position is indefensible. I'm not even talking about whether calling it marriage between same-sex roommates sharing bed is valid or invalid. I'm talking about defending a selective application of the law, and indeed a law that can only be selectively applied in practice, no matter what the Solicitor General of Colorado said. Justices Jackson, Kagan, and Sotomayor got off much sarcasm at the expense of Ms. Wagoner and her client, but in the end, they could not shake the petitioner's position. Nor could they help the respondent or the friend of the court out of the logical traps into which they had fallen. If anything, Olson and Fletcher dug themselves in deeper. Did no one ever tell them that when you're in a hole, stop digging? Olson and Fletcher's twists of logic shook even the Chief Justice's usual studied neutrality. So, barring a reversal of outlook on the part of the justices that strains credulity even to imagine, I can indeed predict the outcome, and on the basis of the questioning, the reactions to the answers, I predict a result of 5 to 3 to 1. Or maybe that should be 5 to 1 to 3. Justices Alito, Barrett, Gorsuch, Kavanaugh, and Thomas forming the majority and voting to reverse the appeals court, Justices Jackson, Kagan, and Sotomayor dissenting, and Chief Justice Roberts concurring in the judgment. Change Jackson to Breyer, and you have the same distribution of votes that we got in Dobbs versus Jackson Women's. Lorie Smith sought a preemptive strike against Colorado's compelled speech law. I think she scored a direct hit And if Alito or Thomas writes to the court, and I have every reason to believe that one of those two will, the damage will prove irreversible. Link in the description of the article to the docket listing, sound recording, and transcript for 303 Creative versus Elenis, to Todd Starnes' tweet with that minute-and-a-half sound bite of Gorsuch laying it on the line with Olson, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and ourcivilized.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and links to at least my past video on the 3 big cases that will dominate this term of the court, and maybe a couple of episodes of the Tulsi Gabbard show that seem relevant to me. This is Terry A. Hurlbut delivering another Declaration of Truth and reminding you to let the truth set you free.